So today we're going to finish up this module on contracts and agreements according to ISM. So we covered purchase orders, elements of the contract, letter or elements, all that good stuff yesterday. And we're going to pick up with something called considerations in preparing obligation documents, which is what a PO is. So patents, intellectual property, this is a big deal, becoming bigger with all the software. So a monopoly created by law is a patent. It must secure rights to use it, usually need a patent indemnity clause in contracts to protect the supplier against infringement on other patents. What this means is we're buying a part from some supplier, but the supplier either unknowingly or on purpose copied something that was patented, and then they come back and sue us too. So if we're indemnified against that by the supplier, then the supplier has to pay for all that. But if you got questions or you're sourcing from certain Asian countries, doing a patent search through legal is a good idea. Copyrights granted to the author of literary, artistic, or audiovisual work. So all your recording artists have copyrights and all your authors. Trademarks used in advertising. So this is like the Coke logo, the PACCAR logo. Those are all trademarks. And then they've got the Madrid system for international registration. Allows you to file one application with a bunch of companies or countries. And it's administered by the WIPO, World Intellectual Property Office. Licensing. So this is the owner of the intellectual property can rent the right to use it. And confidentiality, you guys all know what that is. Royalties. So royalties and licensing are similar, but a royalty is a flat out cash payment made for the use of the patented or copyrighted material, such as a recording artist getting a royalty every time their song is played. Or an author getting a royalty for every book that is sold. Consideration of domestic and international law. So you've got the UN Convention on Contracts, CSIG. Our attorneys don't like CSIG. We usually don't pay attention to it. But it's modeled after the Uniform Commercial Code. And countries must have accepted the law. I think the US has accepted it, although there's nothing that says the company has to follow it. Data privacy. You know, you can see that Europe's very stringent on data privacy. We're getting more so. Advanced notification of consent to subcontract. So this is paragraph 27 of our T's and C's. What this is called assignability. So the supplier cannot assign our work to a subcontractor without our consent. And they can hire tier 2 suppliers, but they can't outsource the entire thing. That's assignability. It is not mentioned the supplier is free to subcontract. For subcontractors, the buyer usually retains the right of refusal. And we don't, I mean, all our contracts say you got to check with us first, but nobody checks with us on tier 2 suppliers. When they're talking subcontractors, what they're really talking is final assembly and doing the whole thing. PACCAR assignment, paragraphs 27. Insurance. So we have insurance requirements in our T's and C's. Paragraph 20. Buyer needs to obtain certificates of insurance and be named as an additional insured. We didn't usually go to those links, but we can. Supplier and subcontractors who come onto the buyer's company's property must have adequate insurance coverage for personal injury. And PACCAR's insurance clauses in paragraph 20. Indemnity refers to being reimbursed for penalties or liabilities incurred by one party because of another's action. So it's also called hold harmless or save harmless or defend clauses. So it requires the supplier to defend PACCAR in court if we're named as part of a lawsuit. So our supplier violates a patent of some other company. That company's going to sue our supplier and they're going to sue us because we got deep pockets. So in that case, the supplier will have to indemnify us for those legal fees. Indemnity clause in our T's and C's is paragraph 22. Standard clause is one way. A supplier indemnifies PACCAR. Most suppliers are okay with that, but we can also do two-way indemnity clauses if the supplier gets really worked up over it. Types of lawsuits: claims by laborers, patent infringement, intellectual property, product safety, general liability. Those things are all good. And the T's and C's need to include buyer protection for product safety and recalls, intellectual property. All that stuff's 15, 18, and 19 in our T's and C's. And then termination and exit clauses. Termination for convenience. This is certainly in our LTAs. I guess it's also in paragraph 4 of our T's and C's. Supplier doesn't have to do anything wrong. We just want to terminate. Force majeure. Now this one became quite popular. It really translates to a superior or irresistible force. Sometimes translates to acts of God that cannot be reasonably anticipated or controlled, such as the global pandemic. In contracts, this refers to an event that excuses a party in whole or in part from performance obligations. So the law does not automatically provide for it. It's got to be written into the contract. And most of our contracts do not start with this as part of the template. We don't offer a mutual force majeure clause to suppliers. That may have changed. We didn't used to. Force majeure does not include non-performance by tier 2. So just because your tier 2 supplier didn't ship to you on time or at all, that is not a force majeure event. That is your problem. Go fix it, Mr. Supplier. Force majeure means it is impossible for the supplier to perform the contract, not that it will cost more or take more time. Business continuity. So clauses that address responsibilities that should be taken if a disaster or other event disrupts the performance of the contract. We have this in our T's and C's, paragraph 5 and 28. Disaster recovery, actions and expected recovery timeframe, and assurance of supply. Contingency plans for in the event of a disaster. Source code on escrow accounts. So for Copics, when IBM decided they were going to abandon that software, we had them put the source code into an escrow account. So then we could update the software. Limitation of liability. You see this not super frequently, but frequently enough. Try to limit the liability and warranty claims like with a cap. Suspension allows the buyer to stop work under contract on a temporary basis due to delays or changes in management. So this is one of the serious things with suppliers, change in management at the top. Got to figure out what direction they're going to head. And reservation of rights prohibits supplier from making any change to the contract without the buyer's approval. That's paragraph 1 in our T's and C's. And then there's the waiver clause, protects the buyer from contractual rights in the event the buyer inadvertently fails to enforce certain rights. So we just forget, but paragraph 27 says it's still active. And then my favorite, promissory estoppel. If one party makes a promise, they cannot renege on it if the other party has acted in reliance on it. So if I tell my gardener, come on over to my place and garden, I'll pay you $300, and he does the gardening, and then I say, oh, well, no, I didn't really mean that. You can invoke promissory estoppel because he acted on my promise. Surplus and obsolete inventory. How's it going to be handled? Paragraph 25 of our T's and C's covers that. Ethics and social responsibilities, interesting enough, in paragraph 17. And state of domain of jurisdiction, which state or country's laws will apply. It's a big issue in international procurement. And this is PACCAR's legal venue paragraph 27. So If they got a new attorney for the supplier, then he's always going to want to change this. And we just say no. Often we can split compromise and do Delaware, because everybody's incorporated in Delaware. Types of damages. So liquidated damages is sum agreed upon for a breach or partial breach of a contract. So depending on the language, it can be awarded for items such as inadequate service, downtime, and equipment, but it's written into the contract. Late deliveries, award for restitution, not penalty, can be activated by a partial breach. But if there's nothing in the contract, then you got to go to court to get it. And it's not going to be liquidated damages. It's going to be general or direct damages. Assumed to be foreseeable includes incidental and special damages. So these are subcategories of direct or general damages. So incidental, which is indirect damages, expenses incurred in inspection, receipt, transportation, care of goods that are rejected, etc. And special damages is what every supplier hates to see in our contracts, but it's in there. Unique to a given situation, for their foreseeability must be proven. Consequential damages are a subcategory. And it's really not special damages they hate, it's consequential damages. So loss that arise directly from a party's action. So lost profits is a consequential damage. And suppliers usually do not sign up for that. And then, so that's general damages. And then you've got punitive damages. Usually on an award for deliberate or egregious acts, you got to be liable. And then we got warranties, express warranties, which are the warranties that are written down, made by the supplier concerning the performance of the goods. And then there's implied warranties, and this comes from the Universal Commercial Code. A buyer does not have to list them in the contract to make them apply. Includes things like title and authority to sell. In other words, I have full legal ownership of the goods. Implied warranty of merchantability means it's of at least average quality and suited for the purposes for which I'm telling you they're designed for. Fitness of intended purpose is kind of similar. If you're relying on my expertise as a seller, the goods I'm selling to you got to be suitable for that purpose. And latent conditions, not identifiable under normal inspection, discovered some months later. So the classic example is if you grab the circuit board with your bare hands and then you fry or degrade some of the electronic components on there, and they pass inspection and go out to the customer, but 3 months later they fail. Defects in material and workmanship. Supplier acknowledgement forms. We usually try to limit express and implied warranties. So this, anybody that's negotiated warranties, run through this a few times. When does the warranty period begin? For us, it needs to be when the customer picks up the truck, because it can sit at the dealer for a while, at receipt and installation, etc. Remedies. So to cure, you have to give the supplier the opportunity to cure or correct the defects, thereby fulfilling the original contract. They can send you a new part. You can send the old part back to them. They can repair it and send it back to you. They can just give you cash. That's called a cure. Cover, buyer obtains replacement goods in the open market and recovers costs and other damages from the seller, or covers costs. So cure is allowing them the opportunity to probably repair it, and cover is allowing them to go out into the open market and buy a replacement. And then PACCAR warranties. I think you guys know where this page is at. And then required documents. Scope of work, SOW, defines what work needs to be done. Sometimes they'll have work breakdown structures and milestones, sometimes not. Specs, which is, what we need to source from. And then the service level agreement, we'll cover that more in 1 Echo 8. This is called an SLA. It's indirect market or indirect purchasing kind of document. And then the item price list. All right. So the supply manager for a small metal fabricating firm in the USA called a gardener, called a gardener and requested he plant a variety of tulips in the front entry of their facility. After some discussion, he agreed to a price of $450. The gardener completed the job as promised, but the supply manager refused to authorize payment. So which of the following obliges the supply manager to pay for this service? Any answers? Come on, guys, we just covered this.
A.
Yeah, A it is. Promissory estoppel. You can't make a promise of payment and then go back on it. It is. All right, there's 7 more questions out there. It's the 1D1 above, so go ahead and jump on those, and we will cover answers at 2:25. Or raise your hand and we'll cover them early if everybody gets done. Yeah, so start on page 3.
Hey, Rick, do we have access to this?
Yeah, I probably haven't given you access, but everybody else does, so I'll remember to do it after this.
Okay.
Oh, Catherine, I don't know if I misunderstood, but questions, I load them up into the chat.
Yeah, Angelica shared with me, but thank you.
we are at 2:25, so let's go over some answers here. I'll post these up in the chat after we're done, so if you didn't get through all of them, you can work through them. 8 is delta. The other considerations are more prevalent and potentially more serious unless the company is in the website design business. The supplier that designed a new product launch website is not a potential competitor. 9 is alpha. If one company indemnifies another for something like patent infringement, they're saying it will not cost the company being indemnified anything if they get named in a lawsuit. 10 is Charlie. Because while neither express nor implied warranties are mentioned, they are both always present in a warranty agreement. By not allowing Acme to cover, the supplier is saying that the replacement parts can only come from them. 11 is Delta, requiring that source code be put in escrow will ensure that Acme has access to it no matter what happens to the supplier. 12 is Bravo, because force majeure means that it's impossible for the supplier to fulfill the contract because of some event, not that a tier 2 supplier is late. 13 is Alpha. Most companies will accept a neutral venue since they are registered there or have legal contracts in those states. New York and Delaware are pretty common. And 14 is Bravo. Consequential damages are damages that arise from some other act and result in things like lost profits. This is an uncapped liability, which is why most of your suppliers hate it. All right. Any questions?
What was 14 again? I'm sorry, I missed.
14?
Yeah, I
Bravo.
missed. Okay, thanks.
Yeah, it's consequential damages or damages that arise from some other act. And what the suppliers hate about them is their uncapped liabilities. They can go as high as they like. All right. We'll talk some more legal stuff tomorrow.
Thanks, Rick.
Thank you.
Yeah.
Thank you.